Hello, good afternoon, everyone.
Good afternoon.
Good afternoon.
Good afternoon, sir. Good afternoon, Imran sir. How are you? We are just starting with the webinar right now.
Right, sir.
Abdul Rahman is talking to himself because he's got his mic on mute, so we can't hear him.
Sir, your mic is muted.
Oh, am I audible?
Yes, sir.
Yes, sir. Perfectly.
Yes,
Thank you. Now I'm audible. Yes.
Good to see you, Justice Abdul Rahman, after a long time.
I have not seen any other body, any other person. My Lord, Mr. Justice Iman Ali, I'll be thrilled to see him.
Well, if you want to see me, then you have to turn your picture on.
Yes.
Okay. Sir, thank you very much for joining us today. We will start with the introductions. So, good afternoon, ladies and gentlemen. My name is Barrister Saqib Mangrio, and I'm the Assistant Director Law at SARC Arbitration Council. It is my privilege to welcome you all to this webinar on ADR in Bangladesh, addressing challenges and exploring opportunities in trade and commerce. This event is being organized by SARCO in collaboration with our long-standing partner, Bangladesh International Arbitration Center, from where Mr. Imran is already joining us. I just want to take this opportunity to express my deep gratitude to all of our distinguished speakers and to our collaborator as well for making this event possible and for taking the time to be a part of this. I'll just take a few minutes just to talk about, give a brief background about what this webinar is about. So the focus of today's webinar is trade and commerce in Bangladesh. This topic pretty much is very much at the heart of Bangladesh's economic growth story. With the country's increasing integration into global markets, commercial disputes are bound to arise. Traditional litigation, as we know, often proves to be lengthy and resource intrusive, which creates bottlenecks and that discourages investment and hinders cross-border trade. ADR, alternative dispute resolution, provides a timely and effective alternative. Mechanisms such as arbitration mediation not only help resolve disputes, but more efficiently, but also promote trust among business partners by ensuring neutrality, confidentiality, and expertise-driven decision-making. In the context of Bangladesh, strengthening ADR frameworks can boost investor confidence, streamline trade practices, and position the country as a reliable hub for commerce in the South Asian region and beyond. As we begin our discussions, I encourage all the participants to fully engage with the speakers and ask any questions, since the speakers come from very, very extensive backgrounds, bringing their experiences, perspectives to the table. It is a very rare opportunity to have such high well-regarded individuals in the same event. So here's to an engaging and productive session ahead. Now that we have formally started this webinar, I'd just like to take a minute to introduce our current presiding Director General of SARC Arbitration Council, His Excellency Mr. Choining Doji. Mr. Doji is a seasoned legal practitioner and has previously served as a member of the National Council in the Kingdom of Bhutan. Additionally, Mr. Doji has also served in the Royal Civil Service Commission of Bhutan as well as the Anti-Corruption Commission of Bhutan. Mr. Doji is our fifth Director General, and it is due to his guidance and support that SARCO has been able to continue its important work of promoting the use of ADR in the region. Furthermore, it's because of his efforts that we have been able to organize important events such as this, which brings together people from different spheres of the world, thereby promoting regional cooperation and synergy. Please allow me to welcome Mr. Doji to give the welcome remarks.
It's all right. Good evening, everyone. So I hope, am I audible? Or?
Yeah.
Okay,
Yes.
okay, thank you. I would like to welcome to this webinar to all the participants, especially to Justices Ali, Rahman, and our esteemed speakers, Mr. Rahman, Mehboob, and Imran. I think you know very well, we have 11 or 2 key mandates which are laid out in the establishment agreement. And if you summarize these 11 mandates into into very neatly, I mean, concise manner, into 3 broad area. One is to provide a very efficient, transparent, and fair legal framework for arbitration and mediation. The second one is to promote the growth of arbitral institutions in the member states. And the third one is to really administer or manage the arbitration and media cases. Last year, we have done a little bit of assessment how we are faring in these 3 broad mandates. And our conclusion was, so far as legal framework is concerned, we are doing pretty much well. We managed to revise our rules of procedure for mediation and arbitration last year, and it was approved by the relevant authorities. And these are in force right now. The second one is in terms of growth of promoting the growth of arbitral institution in the region. I think here also we are doing pretty much well. Every year we conduct a series of workshops, seminar, and webinar across the member states. And last year we had one workshop in Dhaka, and it went very well. I don't know whether any of the justices or speakers, I guess, looks very familiar after a long time. I think most of you participated in that workshop. And today's webinar on the ADR and Bangladesh, addressing challenges and exploring opportunities in trade and commerce. I think this is follow-up activities of our last year's successful workshop. As I mentioned earlier, I think the 2 of the mandates we are doing very well. The third mandate, in terms of relegating the arbitration and mediation cases, I think this is where we are lacking very much. And of course, in the last, I don't know, 12 or 13 years, we have had only 12 cases, which are mostly conciliation cases. And this is one of the areas now, I mean, moving forwards from here, we are trying to focus in this area. Of course, this does not mean that we are going to neglect in other areas. In terms of promotion of arbitral institutions, we'll go ahead as it is, as planned. Every year we will conduct the workshop, seminar, or more tailor-made training programs. In terms of really getting the arbitration and mediation cases, I think this is the area I think we need your guidance, your advice, and your partnership and collaboration. And this is the area we would like to focus moving ahead. And my assistant director talked a lot about the seminar, the expected outcomes, and how it is going to be proceed ahead. I don't think I need to repeat, but I would like to urge all the participants to engage with a fellow participant, engage fully with the resource speaker, take advantage of their experience, knowledge, and expertise. And I guess any workshop, any program, any activities is as successful as the participants interact with each other, with a resource speaker, clarify from the doubts from the resource speaker and from the fellow participants. And I would like to encourage your engagement, be active participation. And I think I should leave more time for resource speakers to speak, and then also for Q&A session that will follow later on. I wish everyone a very successful and enriching webinar. Thank you very much.
Welcome.
Thank you, sir. So before we commence our thematic sessions, I would just like to take a moment to thank and also say a few words about our chief guest, Justice Muhammad Iman Ali, former Justice of the Appellate Division, Supreme Court of Bangladesh. Justice Iman Ali received his education in the United Kingdom, where he completed his schooling, pursued his law degree in LLM, and qualified as a barrister at law. He has practiced law both in Bangladesh and in the UK, bringing with him a wealth of cross-jurisdictional experience. He was appointed as Deputy Attorney General for Bangladesh in 1998, before being elevated as Judge of the Supreme Court High Court Division in 2001, and subsequently to the Appellate Division 2011. Throughout his illustrious judicial career, Justice Iman Ali has made profound contributions to the development of law and justice in Bangladesh, with a particular focus on justice for children. His landmark book titled Towards a Justice Delivery System for Children in Bangladesh, published by UNICEF in 2010, along with his numerous articles and lectures, have been instrumental in shaping discourse on juvenile justice. He has trained judges, prosecutors, police, lawyers, and officials both in Bangladesh and abroad, including Armenia, reflecting his deep commitment to building capacity and strengthening justice systems. Justice Iman Ali's remarkable contributions have been recognized internationally as well, since in 2014 he received the Juvenile Justice Without Border International Award from IJJO Brussels, and in 2020 he was awarded the International Mediation Award from the Africa-Asia Mediation Association. Beyond his judicial service, Justice Iman Ali has been a strong advocate for the use of ADR, promoting its value through lectures, discussions, and in his judgments. His lifelong dedication to justice, human rights, and reform makes him an inspiring figure for all of us gathered here today. Ladies and gentlemen, please join me in warmly welcoming Justice Muhammad Iman Ali to deliver the special remarks.
Thank you very much. Yes, first of all, I'd like to say a warm welcome to everyone, and thank you very much for inviting me on this occasion. It's a very important topic. ADR has been in the books for a long time now. I won't go into the history of dispute resolution, because that goes hundreds of years. But what I will do, and what I would like to do, is to tell you about the ADR system that was introduced into Bangladesh. I remember it well because at that time I was just a newly appointed judge. In 2003, Justice Mustafa Kamal, Chief Justice of Bangladesh, and another judge, late lamented Justice Anwarul Haq, both were involved in the training on ADR, and at that time they were trained in America. They both came back after their training, and the Section 89A of the Code of Civil Procedure was introduced in 2003. And 29A, B, C, D, etc. They deal with ADR, mainly arbitration and mediation. The main focus was on arbitration and mediation, although there are, as the previous speaker has said, there are other ways of dispute resolution, including negotiation and conciliation, amongst others. So in 2003, the law was changed. But unfortunately, and with all due respect to learned advocates, I must say that it was the lawyers who were not very happy about ADR, because they felt that it was taking away their business, their day-to-day business in courts, and that was being hampered, or that would be hampered by ADR, and they would lose their caseload and so on. And I remember it well because in around 2007 or 2008, Justice Anwarul Haq was having a meeting in Cox's Bazar on ADR, trying to encourage the lawyers to adopt methods of dispute resolution through ADR. And he was not getting very far. I was in Cox's Bazar at the time dealing with a seminar on child rights. He asked me to come and say a few words to the learned advocates who were present in the meeting. And I acceded to his request, and I said to the lawyers, look, yes, you will be losing your cases because ADR is much simpler, it's quicker, and it'll be all done so quickly that you will not get your fees that you get over the years, keeping a case alive from year to year and milking the cow, as it were. But I try to tell them that ADR is a system which works fast, and if the learned advocates could take on the task of dealing with their cases through ADR, either mediation or arbitration, they would be dealing with more cases. And I gave them the example of a wholesaler who sells his goods much cheaper than the retailer. The retailer sells 2 items, 3 items a month and makes a profit of, let's say, 1,000 rupees or takas. Whereas the wholesaler sells 10 items or 20 items in a week and makes a profit of probably 2,000 or 3,000 over the month. So he makes more profit over the period, but selling more goods, although the price is much lower than the retail price. The analogy is that if the lawyers can dispose of more cases through ADR, they will get a fame as a quick disposal method, quick disposal lawyer, and they'll get more cases coming to them because, after all, the litigants want quick disposal. They want to resolve their issues so that they can get on with life and not have to wait for years on end to get their dispute resolved in the courts. Now, unfortunately, I have to tell you that having dealt with ADR, arbitration, and mediation over the years, with all due respect to people who do ADR, who do arbitration, I myself, and I know Justice Abdul Rahman does arbitration cases. But I have to tell you that arbitration has become rather cumbersome and perhaps more expensive than other forms of dispute resolution. And the idea of ADR was threefold: quick dispensation, cheap dispensation, and an more or less amicable settlement so that the parties can continue their relationship of business in particular. And today we are talking about business involvements. Now, the problem with arbitration is that it has, over the years, become more time-consuming than it was initially. We have cases on arbitration which do tend to go on because of either party taking more and more time, and as a result, it becomes more expensive. Arbitration in any event is quite expensive because the arbitrators charge quite a handsome fee, as well as the lawyers, they charge quite a handsome fee. But in spite of that, arbitration is much better than litigation because litigation goes into not just years, but goes into decades. We have disposed of cases in litigation, which I know for one, started in the 60s. And that was sitting in the appellate division in the 2020. So arbitration is better than litigation. But what I would like to suggest is that mediation is better than arbitration. And that has been recognized, I believe, across the globe now. In particular, you will note that in the UK, for example, mediation has now become compulsory, which it wasn't before. Although in Bangladesh, surprisingly, mediation was made compulsory through Section 89A. And the problem was that the lawyers were not interested because, as I said, it took away their milking cow. But the judges also were not very much aware, nor indeed excited about using mediation or arbitration for that matter, because the parties didn't want it. And who is the party? The party, of course, in court is the lawyer who represents the party. The party, if he had the say, would have said something different. He would have said, go for mediation, we will finish it quickly. Mediation takes a few sittings. I don't know whether any of you do mediation, but mediation cases can be disposed of within a few sessions, maybe 2 or 3 sessions, maximum 5, 7 sessions, and then it is done. In fact, mediation is time-bound by the law itself. A mediation proceeding can end with a decree within a space of 90 days, according to law, because it is all, the time is all set down in the law itself. Now, what we did in Bangladesh, I don't know whether any of you are aware, was that in 2021, we actually produced a circular explaining to the judges, the circular issued by the Supreme Court, explaining to the judges that mediation is mandatory. I'm sure many of them knew already, but it was not implemented. And then we also issued some guidelines in August 2021 as to how the process should be introduced in court, how the matters should be addressed in court, so that people, the lawyers, the parties are encouraged to get their cases disposed of through ADR. And what we tried to do was to explain to everyone how it is easier to deal with cases under mediation, the benefits of mediation, and of course, as you know, the benefits of mediation are very, as I said earlier, quick disposal, less expensive, and engendering peace. We know in cases of mediation, for example, mediation, as you are all aware, I'm sure, is a case whereby the parties in themselves decide. It is not the mediator who decides the end result. The parties talk and talk and talk more until they come to a resolution amongst themselves. I remember a case in the appellate division. Yes, it was in the appellate division, where in fact one of the parties was a doctor, and the other party was an engineer. It may be a reported case, I'm not sure. And one had issued a check for, I think it was 15 lakhs, which bounced. The engineer issued the check, bounced. So the doctor took him to court under the Negotiable Instruments Act. He managed to get, I think, 5 lakhs because the engineer was actually put into prison as a result of the case. By the time it came to the High Court division, the matter was still not resolved. When it came to the appellate division, we granted the man bail on condition of paying half of the money. And in the end, the bottom line was that the doctor said to us, I don't want to continue this case. And I, for one, said, look, it's your right, it's your entitlement. You will get your money. We'll make sure of that. He said, no, I'd rather continue our business than make him suffer and pay the money, because paying the money, it will take a long time. Whereas if we continue business, I can recover, I think it was about 7 lakhs still outstanding. He said, I can recover this 7 lakhs within a few months through our business dealings and transactions. So he gave up the 7 lakhs because he knew that he could make 10 lakhs in the next 6 months through business transactions. And as a result, what happened? Both parties won. The engineer was out of jail. He managed to wheel his way out of paying 7 lakhs or whatever it was. And the doctor was happy because he was continuing his business transactions with him. The business relationship continued. So there was peace between themselves, which they actually engineered themselves. It was their decision. It's a give and take. Cut your losses and have a happy situation. So that's mediation. I could give you examples of arbitrations which actually went wrong. And that is why I'm not much in favor of arbitration, although arbitration is still better than litigation because it is still quicker, it is still less expensive in the long run. But arbitration, I can give you just 3 cases where, for example, one arbitration started in 2006. The award was given in August 2006. Award was challenged, and the High Court Division allowed the award in part. But the Appellate Division said that under Section 73 of the Contract Act, the party was not entitled to get the award in favor of the plaintiff because the arbitrator had found, although he awarded in favor of the plaintiff, the arbitrator had found that the breach of contract was in fact done by the plaintiff. And as you all know, if the plaintiff is in breach of contract, he cannot get the benefit of his own breach. So the award was set aside, and arbitrator had, in fact, although he found in favor of the plaintiff, he overlooked the fact that the plaintiff was in breach, and therefore he was not entitled to the award. And as a result, 8 years were lost. We decided in 2014. The matter started in 2006. And the cost and expense of going all the way from the arbitration to the appellate division, all gone to waste. Another case where the appointment of, it was an arbitration in 1986. The appointment of the arbitrator was challenged. The High Court Division canceled the appointment. The second arbitrator was appointed, and the High Court Division again set aside the appointment. The third arbitrator actually passed an award in 1997, and there was an application for setting aside the award, which was rejected. It was made a rule of court in 1997. So the matter started in 1886, rule of court in 1997. See how long it has taken. The appeal before the High Court Division was dismissed in 2003, and presumably the plaintiff was quite happy. But then, in 2004, the CPLA, Appellate Division, the arbitration, the award was set aside because the arbitrator continued the arbitration unlawfully. The Appellate Division held that the arbitrator acted beyond his jurisdiction in proceeding when he was made aware that his appointment was stayed and under challenge. So the appointment of the arbitrator, the third arbitrator, was stayed by a court, but the arbitrator, in spite of that, continued with the arbitration and passed the award. Now, it took how many years? 28 years to get to the decision that the arbitration will have to start all over again. And the third case I want to bring to your notice, and this is a reported case, I know it's 15 ADC, page 575. Arbitrator was appointed in 2003, award filed in 2005. The defense then filed an application to file a written objection. The plaintiff made a prayer to reject the written objection. The plaintiff's revision before the High Court Division was allowed in 2012. The defendant went to the Appellate Division. Appeal was allowed in 2013 because the notice of filing the award was mandatory and it was not followed. And we held that although the plaintiff knew about the filing of the award, but the fact that the notice was mandatory and was not, on the facts, was not served, the award was set aside. And 14 years were lost in the process. So arbitration has its drawbacks. If the parties are able to accede to the award, and if the proceedings are taken in accordance with the law, then it is a good method of dispute resolution. But unfortunately, for various reasons, procedural defects crop up. And because the courts are open to all this, the procedure, the whole system of arbitration comes to almost nothing at the end of the day. So what I believe we need is, number one, a thorough knowledge of the laws by the learned arbitrators. There's no substitute for that. Arbitrators cannot afford not to know the basic laws of contract, for example. And that is, as I told you in the first case, that was the main reason why the arbitration was set aside, because the arbitrator simply was not aware of Section 73 of the Contract Act. Arbitrators must know the procedures and must follow the procedures. Although in arbitration, strictly these Code of Civil Procedure are not so strictly applied, in fact, do not apply according to the Arbitration Act and the rules. There's always leniency in dealing in arbitration of procedural issues. But nevertheless, the fundamental law must always be followed. The Code of Civil Procedure does not apply, but the Contract Act applies. No giving notice is a procedural defect. Not giving notice is a defect which the arbitrator must abide by, because otherwise there would not be justice. You cannot have a case or hear a case without having notice properly given to all the parties concerned. So arbitration is good, but there is a caveat. Mediation, on the other hand, is better, I feel, because it is all out in the open. Mediation is not done by the mediator. Mediator is simply a referee. Both parties decide amongst themselves, chatting over their issues, trying to iron out their differences, and at the end come to a decision by themselves, this way or that way, cutting their losses, and thereby you will avoid any appeal, any revision. There is no appeal or revision in mediation. And equally, same as the arbitration, the rule of the court order as a result of the mediation is final. So what I would like to say is that, first of all, the mediators and the arbitrators chosen must know the basic fundamental laws. They must follow procedural norms, not follow the CPC or any other code, but they must follow the basic procedural norms of justice. Notice to parties. And the other thing that I think must be looked into is how to make sure, by providing laws and rules, if you like, make sure that arbitration and mediation orders are given the sanctity that they deserve to make the system work better. If every case of an award is taken to trial because it helps one party or the other, then it defeats the purpose of the dispute resolution, ADR. So again, training judges, I should say, not to entertain challenges against awards unnecessarily, making sure that awards are not challenged only because it helps one party, because delay helps them. Delay saves them money. And if you're dealing with a case for crores of takas, then delay in payment may save them a lot of money, and then that may itself be an encouragement to file an application for setting aside the award. The court must be in a position to see through the mechanism or machination by the lawyers. Again, the lawyers are sometimes very clever. I had one case where the lawyer knew that the court that the award was to be filed in was, because it was an international arbitration, was the district judge in Dhaka. But the other party, unaware of the particular point, filed the case in Chittagong. Although the other lawyer knew that it's the wrong case, wrong place, wrong court, he continued, and it went on for months. And finally, when it came to the High Court division, he said, yes, they should have filed it in Dhaka. So in the process, a lot of time was lost, money was lost for the client, for the litigant, and who gained? Lawyers, of course. So anyway, I don't want to take too much more of your time. I am very happy with the process dealt with by BIAC, Bangladesh International Arbitration Center. And I'm sure that SARCO is also doing the same. We must, I think, this time has come, we must go to ADR, because the court system has been clogged up over the years. There is a huge backlog of more than, I think, 40 million or 4 million. I can't remember exactly what it is now. Justice Abdul Rahman may be able to tell you better.
No, it's 8 lakh.
8 lakhs. 8 lakhs. So that is a lot of cases, and that will never be depleted. It cannot ever be depleted, even if you appoint 1,000 judges to deal with it. So this is the way to deal with it. ADR, solve cases quicker, and most importantly, I would say, ADR disposal saves at least 4 stages in the litigation system. Because any case that you file before a trial court, it goes to trial, it goes to appeal, it goes to the High Court in revision, it goes to the appellate division, it goes for review. Automatically, because everybody wants to try their last to make sure that they get the benefit they think they are due. And that doesn't help the system, the justice delivery system. I feel the ADR system is the only way out for people to get justice quicker and less expense. Now, mediation, I try to encourage mediation, as you may have gathered from what I said earlier. I trained, I believe, about 200 or so lawyers in mediation. And we issued some circulars from the Supreme Court. But unfortunately, I couldn't really get to the end of what I wanted to do. But what I actually wanted to do was to take mediation to the grassroots level. And that is totally possible through the legal aid officer. The law allows it. the legal aid officer who will deal with mediation can deal with that mediation in the local Thana level court, or even union level court if you come to that. We've had dispute resolution through the people in the villages, the panchayat. The village courts, unfortunately, have not been able to do the task because of politicization. Unfortunately, because the chairman and members suddenly became affiliated to political parties, so the mediation was not producing justice in accordance with law. But even that could be changed. Mediation through the legal aid officer, mediation through the court costs nothing. It's free. Even the law allows, if the case is resolved through mediation, the law allows for the fee, the court fee, to be refunded. And it's a win-win situation. So I would suggest mediation to be given preference. Arbitration is definitely there. If possible, of course, the best resolution is negotiation between the parties and or conciliation through some assistance. I'll stop here and I will talk more if anybody wants to hear any more of what I want to say. Thank you very much for giving me the opportunity to say these few words.
Sir, thank you so much for your very interesting remarks. And as you mentioned, there is a lot for us to discuss on that. But because our time is a bit limited, we will move on to our upcoming sessions. But just to add a little to what you said, we've all heard the saying that an ounce of mediation is worth a pound of arbitration and a ton of litigation. And we completely second your thoughts from a Pakistani ADR perspective. And I understand there are a few participants from Bhutan as well as from Sri Lanka, and maybe during the Q&A session we can hear from them as well how much their systems resonate with your remarks as well. So moving on to our first thematic session for today, which is evolving legal and judicial attitudes towards ADR. We have with us to deliver his insights Justice A.F.M. Abdul Rahman, former Justice of the High Court Division and currently Senior Advocate of the Appellate Division, Supreme Court of Bangladesh. While we've already had the pleasure of meeting and hearing from Justice Abdul Rahman in our last year's seminar, which was held in collaboration with BIAC, I'll just take a few minutes to introduce, although Mr. Justice Abdul Rahman needs no introduction. So a barrister of Lincoln's Inn and an advocate of the Supreme Court of Bangladesh, Justice Abdul Rahman is widely recognized as one of the country's leading civil lawyers with over 25 years of standing in practice. Justice Abdul Rahman was elevated as an additional judge of High Court Division in 2003 and confirmed as a permanent judge in 2005. After an esteemed judicial career, he retired from the bench in July 2018. At present, he serves as a senior advocate at the Appellate Division of the Supreme Court of Bangladesh and heads his own firm, Rahman Law Associates and Company, where he focuses primarily on commercial law and maritime arbitration corporate litigation. Justice Rahman is also the author of several notable works, including Towards Establishing a Green Tribunal, Environmental Causes in Bangladesh, Role of Law in Rule of Law, and Upholding Human Rights of the Poor. Epistolary jurisdiction could be instrumental. Truly a jack of all trades in our midst today. Justice Abdul Rahman, I'll now pass on the stage to you, and I welcome you to give your insights on the topic.
Thank you. This is a very good introduction you have given for me, which is may not be true to the context. Yes, my greetings, first gratitude to His Lordship, Mr. Justice Imanli, with whom I practically sat for 2.5 years. And I saw the merit he has got in dispensation of justice to the people of Bangladesh. I salute him. Yes, Honorable Chief Guest, Mr. Justice M.E. Manali, the respected Chair, the Director General, SARCO Arbitration Council, Honorable Speakers in today's webinar, Barrister Muhammad Farooq Rahman and Barrister Shakib Mahbub, distinguished guests from SARCO and BIAC, colleagues, friends, ladies and gentlemen, Assalamu alaikum, and wishing a very good afternoon. I'm really thrilled to get this invitation to speak today on the very burning theme of alternative dispute resolution, ADR and Bangladesh, addressing challenges and exploring opportunities in trade and commerce. My part of today's conversation is on evolving legal and judicial attitude towards ADR in Bangladesh. I speak not only as an arbitrator, since currently I'm engaged in, as has been said, in international commercial and investment arbitration, but also as a former justice of the Supreme Court of Bangladesh. For a number of years, I presided over the arbitration bench in the High Court Division and had the opportunity to gather immense knowledge on the method of alternative dispute resolution, especially on arbitration. When I delivered some reported and widely cited judgment on arbitration, in those decisions, the attitude of the legislature and the higher judiciary towards ADR was reflected, where I consistently took a strict view in favor of the quick disposal of arbitration proceedings and enforcement of arbitral awards, because I believed and still believe that delay defeats the very purpose of ADR, which detracts the prospective party to come to ADR. I hope to share today both retrospective reflections and forward-looking observations of mine. Let me take some introductory remarks before I enter into this subject deeply. I do not hesitate to admit that in Bangladesh, we all know that the formal justice system, our courts, suffer from serious delays, backlog, procedural constraints, cost burdens, and sometimes lack of access, especially to the weaker sections of the society. In this context, alternative dispute resolution, ADR method, namely mediation, arbitration, conciliation, and negotiation, offer not only speed, but flexibility, party autonomy, and often more cost-effective and creative resolution. The evolution of legal statutes and judicial attitude in Bangladesh over the past 2 decades shows increasingly serious engagement with ADR. But many challenges remain: legislative gaps, judicial conservatism, lack of awareness, institutional incapacity, and people's perception. In order to focus on legal and judicial attitude towards ADR, I propose to address the issue in 4 parts. Firstly, recent inclusion and expansion of ADR in the statutes of Bangladesh. Second, key judicial attitude and recent decisions of the Appellate Division and the High Court Division of the Supreme Court of Bangladesh. Third, people's perception as to the attitude of the legislature and the judiciary and connected our structure and opportunities. Fourth, some suggestion to way forward from me. On the first instance, let me elaborate the legislature evolution in inclusion ADR in our laws. Unfortunately, till 2001, we did not bother with the century-old arbitration law titled Arbitration Act 1940, enacted during the British regime in this subcontinent. But over the time, the business and investment situation got international momentum when the age-old enactment became incompetent to cope with the current complicated commercial affairs. This has prompted Bangladesh to decide to bring ADR into its statutory framework. The initiation commenced with the repeal of the existing Arbitration Act 1940 and enactment of the new Arbitration Act 2001 on the basis of ancestral model law. Later, a number of existing statutes were amended to include ADR as a pre-method to adjudication of the dispute through the regular court system. The aim of the inclusion of ADR method in different existing statutes is directed to boost the investment situation actually by satisfying the intended foreign investors in Bangladesh who express their desire to invest through foreign direct investment scheme under bilateral investment treaties. The new law, along with its all the drawbacks, has satisfied the prospective investors to some extent that there is a modern statutory speedy private resolution system available in Bangladesh to resolve any unwarranted probable commercial dispute, either investors to government or investor to investors. Therefore, the Arbitration Act 2001 is our principal law governing one of the well-known but not popular ADR method, namely arbitration, both domestic and in many respects international, as far as enforceability, setting aside, procedure are concerned. Second comes the Code of Civil Procedure 1908, CPC. This is a century-old procedural law to resolve civil dispute, especially property dispute. In 2003, as His Lordship Mr. Justice Emmanuel has said, the third amendment of the CPC inserted section 89A, 89B, and 89C. These sections allow the court to postpone hearing in order to effect mediation or send parties to mediation, etc. Though through another amendment, stronger language subsequent to the earlier amendment, stronger language was introduced within the ADR provisions, inserting the phrase "the court shall," etc., making some mediation referral more mandatory in certain circumstances. Further, the legislature introduced ADR provisions in Income Tax Act 1984, the Value-Added Tax 1990, and other few statutes. But since the Income Tax Act 1984 was repealed, the newly enacted Income Tax Act 2023 has more recent edition of ADR method. Under the Income Tax Act 2023, the rules preceding it, there is an elaborate ADR scheme for tax dispute. The scheme provides for facilitator and allows an assessee to apply for ADR in respect of dispute pending before the Income Tax Authority or the Tax Appellate Tribunal, except in situations already under the jurisdiction, to negotiate under supervision of facilitator, etc. The ADR mechanism here stays the appeal or reference until the ADR application is disposed of. There are ADR in form of mediation and conciliation provisions in family laws, in family courts, and in certain statutory boards. The Muslim Marriage and Divorce Act 1974, the Conciliation of Dispute Municipal Areas Board Act 2004 are such statutes, including the Village Court Act, family laws involving family arbitration council under Muslim family laws ordinance, etc. Thus, the legal infrastructure for ADR is increasingly well laid. The laws provide for mediation and arbitration, for judicial referral, for facilitator roles, etc. But law is only one side of the coin. How courts and judges interpret and apply laws regarding ADR is equally vital. Now I will enter into the issue as to the judicial attitude, what the courts are doing in encouraging ADR, how our judiciary, especially the High Court Division and the Appellate Division of the Supreme Court of Bangladesh treated ADR, and what is the judicial encouragement in favor of ADR. At various times, the Supreme Court of Bangladesh, through its both the divisions, has encouraged parties to use ADR to reduce case backlog and to settle dispute amicably. It is now common to courts to ask as a first instance question, is there an arbitration clause? Can matters be referred to arbitration? The jurisprudence under the Arbitration Act has become formal. Over recent years, courts have been interpreting the provision of ADR more purposefully, especially sections relating to jurisdiction of courts, arbitral tribunals, power to rule on its own jurisdiction, challenges, etc. I'll refer only 3 cases briefly from only 2023 and enumerates the block summary of important arbitration judgment of Bangladesh Supreme Court in 2023. In the case of Bangladesh Rural Electrification Board versus Bangladesh Energy Regulatory Commission and others, this has been done in a civil appeal number 18 and 20 of 2029. It's an unreported one. There the question was whether the procedure prescribed for a named arbitrator in the agreement can be ignored. The court held that the parties should be bound by what they agreed, especially concerning appointment of arbitrator, etc., under Section 43 of the Arbitration Act 2001. In the case of Big Boss Corporation versus Army Welfare Trust, it has been reported in 17 Scope 2023, page 57. The issue was delay in challenging an arbitral award. The court held that the Limitation Act provisions are applicable and that in arbitration matters, delay beyond the statutory period is fatal. In the recent case of Mustafizur Rahman versus Amin Maria and others, reported in 75 DLR, in the question raised as to whether an arbitration agreement can be incorporated by reference to another agreement. The High Court Division upheld that, yes, where parties have agreed in a Bayanapatro, that is the contract for property sale, to be bound by terms of another contract, which includes an arbitration clause, incorporation by reference is valid. On the question of jurisdiction and tribunal's power over its own jurisdiction, the court's view is that under the Arbitration Act 2001, Section 17, including Section 17 core, etc., give the arbitral tribunal the power to decide its own jurisdiction, whether there is a valid arbitration agreement, etc. Courts have in recent cases refused to usurp the power. The threshold test is reserved for the tribunal unless there is no arbitration agreement at all or it is manifestly void. On challenges to arbitral awards, setting aside, etc., courts have been insisting upon that parties must raise timely objections. Otherwise, rights are waived. Courts are interpreting limitation, challenge composition of tribunal procedure in a stricter manner. For example, in the Big Boss Corporation case, the court held delay beyond the statutory period is fatal. Our judicial attitude towards ADR is increasingly influenced by international arbitration norms, unsettled model law, international arbitration jurisprudence. For example, the doctrine that the tribunal can rule on its own jurisdiction, competence is in the Arbitration Act, and our courts are accepting that in spirit. The requirement to give effect to arbitration agreements, judicial proceeding, stay, or refer to arbitration unless arbitration agreement is void or incapable. Courts in many jurisdictions, India, UK, Singapore, etc., have similar attitude. Although I do not have a recent Bangladesh Supreme Court case involving binding non-signatories doctrines, these doctrines appear in other jurisdictions and are being discussed in academic and legal practice. Despite this progress, there are cautious approaches. Some courts are still reluctant to impose ADR in particular cases. Sometimes the mediation referrals under Section 89A, etc., are not exercised or are exercised perfunctorily. Some judges feel that parties may be unequal in bargaining power, concerned about ensuring fairness, cost, proper appointment of mediators or arbitrators. Also, sometimes court procedure backlog, limited institutional support, inhibit full realization. Now, I will shed some light on the issue of people's perception, challenges, and opportunities. Even with good laws, the better judicial attitude, the real question is, how do litigants, lawyers, business people, public perceive ADR? What obstacles remain? What are the opportunities? Many view arbitration and ADR more generally as less formal and thus perhaps less enforceable, less predictable, or less rigorous than courts. There is sometimes mistrust that arbitrators may lack transparency or that or that hours will be difficult to enforce, etc. Among general public or small litigants, lack of awareness of ADR option, cost of arbitration in commercial cases, legal fees, uncertainty about process, institutional cost, etc. really matters. Moreover, lawyers traditionally prefer court litigation, as His Lordship Mr. Justice Imran Ali has said, because of their prestige, established practice, sometimes fixed fees or habit. More so, they are doubtful about the institutional capacity that is the mediators, conciliation boards, arbitration institutions, tribunals, infrastructures are still underdeveloped. It is true that there aren't always available robust panel of neutral, well-trained mediators and arbitrators easily available everywhere. Even if arbitration awards are made, setting aside clauses, appeals, jurisdictional challenges, and sometimes delay and cost enforcing remain concerned. If ADR is not efficiently managed, it can become expensive or protracted. Though many laws include ADR provisions, some important areas have weak or no ADR option. Definitions, time limits, standard practice, etc. Also, sometimes the wording of statutes, that is, whether ADR is may or shall, etc., leaves discretion. With the encouragement of the legislature and the indulgence of the judiciary in international and cross-border trade, arbitration is already well respected. Bangladesh, as a contracting state to certain international conventions and via the Arbitration Act, is increasingly accommodating party autonomy, enforceability of foreign awards, therefore under the New York Convention offer much scope. Tax law, ADR, are in the Income Tax Act 2023 is a high potential opportunity, both to reduce dispute, reduce litigation cost, and improve revenue certainty. Now, I'll make some suggestions and make a way forward drawn from both domestic experience and international arbitration practice, which might strengthen the evolving legal judicial attitude and make ADR more effective in trade and commerce. Firstly, stronger legislative mandates are required. Laws should more explicitly make ADR referral mandatory in suitable cases, especially for commercial contracts and arbitration clauses. Cases below certain monetary threshold, tax dispute, etc., should be the field to act unless exceptional circumstances prevail. Careful drafting to avoid ambiguity between may and shall is essential. Secondly, judicial training and sensitization, as His Lordship Mr. Justice Imran Ali has said, are required. Judges must be well versed not just in arbitration law, but in mediation, conciliation, and psychology of negotiation. Ethics of ADR. Bench books are regular training on the ADR perspective may be held with the interchange with arbitration centers like Bangladesh International Arbitration Center, BIAC. Thirdly, development of arbitration and mediation institutions are required. More established ADR centers, both in Dhaka and in the region, panel of certified arbitrators and mediators, standard rules and fees, transparency and neutrality, accreditation are required to be developed. Fourthly, the enforcement mechanism, clarity has to be well focused. Courts must adhere to principle under Arbitration Act. Therefore, limited review only on prescribed grounds, enforce foreign awards, avoid unnecessary interference, also produce well-reasoned judgment-setting precedent. Fifthly, awareness building among lawyers, business persons through public seminar, incorporation of ADR in law school curricula, public information campaign, etc. has to be well publicized. Sixthly, cost regulation and procedural efficiency should be on stricter rules. Rules to ensure ADR proceeding are not unduly complex to limit cost, perhaps scaled fees for small dispute, timeliness for mediation and conciliation. And seventhly, last but not the least, incorporation of international best practice, drawing from ancestral model law, best practice from SIAC, Singapore, LCR, London, ICSID, ICC, etc. are required. For example, competence, binding power of arbitration agreements, recognition of arbitration provisions, etc. should be made in binding rules, which is yet to be formulated in Bangladesh. Before I conclude, I'll say that there has been a visible shift in judicial approach from treating arbitration or ADR merely as contractual technicality to seeing it as key to facilitating trade, commerce, and investment confidence. Courts, and in particular, recent benches of the High Court Division and the Appellate Division of the Supreme Court of Bangladesh are increasingly insisting on giving effect to arbitration agreements unless there is real defect, weakness, or illegality. They are showing less tolerance for delay, taking whimsical objections, especially after a long delay. But some judges still, perhaps due to conservative mindset or lack of expertise, hesitate to refer when arbitration clauses are badly drafted or mediation when parties seem not fully able. The Supreme Court was to some extent consistent in reported judgment, 2023, etc., but more leadership, therefore large full benches publishing clear guidance, ailing lower courts practice would help. In conclusion, I'll sum up that the evolution of legal and judicial attitude towards ADR in Bangladesh is promising. The statutory architecture is expanding. Courts are increasingly willing to enforce arbitration agreements, to refer parties, to set standards. The ADR provision in the Income Tax Act 2023, among others, are especially promising for trade and commerce, where predictable dispute resolution is crucial for confidence and investment. Yet, substantial work remains pending. Legislative refinement, institutional capacity, judicial training, cost and enforceability concern, and ultimately public awareness must be addressed too. For our trade and commerce to flourish, foreign investment, domestic contracts, infrastructure disputes, investors, state matters, ADR must not be a sideline, but a core part of dispute resolution culture in Bangladesh. I believe that with concerted effort among the judiciary, legislature, legal professions, arbitration and mediation institutions, and with the flourishment of the civil society, Bangladesh can become a regional hub for efficient, fair, and trusted ADR. Thank you all once again, and I look forward to the discussion and your thoughts. Thank you.
Thank you, sir. And thank you for the action points that you mentioned at the very end. I think they have very universal applicability in the South Asian region because a number of points I could relate from a SARCO perspective too. For example, the perception part which you mentioned, we had an internal study on that just to make sure that how do we improve that. And with regards to the best practices as well, we have been engaging with a number of international experts, as you mentioned, from Singapore or from ICC, to better improve ourselves and then also share those insights with our partners too. And of course, we try our best, and we have been for the last 3-4 years to do as much good marketing and awareness programs as we can to improve the scope of ADR throughout the region. So, sir, thank you once again. And we'll move to the next thematic session. The second thematic session for today's webinar is titled Institutionalizing ADR in Bangladesh. It is my honor to introduce Mr. Barrister Mohammad Farooq Rahman, our long-standing partner and one of the leading dispute resolution experts of Bangladesh with more than 2 decades of distinguished practice. Additionally, he is also an advocate of the Supreme Court of Bangladesh. Mr. Rahman specializes in arbitration, litigation, mediation across sectors such as shipping, aviation, energy, construction, trade, and commercial law. He is regularly ranked by the chambers and partners in dispute resolution and shipping, where clients praise his depth of knowledge, responsiveness, and clear commercial advice. Mr. Rahman holds an LLM in International Dispute Resolution and postgraduate diplomas in Maritime and Commercial Law from the University of London. He is a fellow of the Hong Kong Institute of Arbitrators, a member of both the Chartered and Singapore Institutes of Arbitrator, and also serves as a panel on the panel of arbitrator for Bangladesh for SARC Arbitration Council as well. He is also a member on the panel of the Shenzhen Court of International Arbitration, and is also a CEDR accredited mediator. As the founding head of chambers at Rahman's Chambers, Barrister Farooq Rahman has built a reputation for handling complex cross-border disputes and international arbitrations. In addition to his leadership roles in various global arbitration bodies, including the ICC Commission on Arbitration and ADR. Farooq sir, it's again my honor to have you in our middle today, and thank you so much for taking the time to be a part of this webinar. And I'll now move the floor to you for your insights.
Thank you, Saqib Bhai, for the introduction. Honorable Chief Guest, Mr. Justice Retired Iman Ali sir, and Honorable Director General Mr. Joining Dorji, Honorable Justice Abdul Rahman sir, and my fellow learned colleagues, and ladies and gentlemen, Assalamu alaikum, and very good evening. I'll be talking on institutional ADR, as we already heard from Honorable Justice Iman Ali sir and also Abdul Rahman sir about the initiative that is taken by the judiciary, and also statutory arbitration, which are made mandatory, for example, BRC, taxation. So these parts I will be avoiding, because my topic is institutionalized ADR, which means that the drive by the particularly the private institutions like via SARCO, I mean, how to promote ADR with the initiative of these institutions. So I'll be sharing a slide for making the presentation. Please bear with me. Okay. Yeah. Let me briefly introduce the institutions which we are in an ecosystem involving ADR. So if you are talking about institutionalizing ADR in Bangladesh, we'll have to know the where it fit in, where, for example, where Bangladesh International Arbitration Center and SARCO fit in. And we'll have to also measure their scope of service compared with the other global and regional institutions which are operating in the same area. I mean, locations may be different, areas of expertise may be different, but I mean, all are operating, and we'll have to know the institution first. Number one, let me start with the first slide, domestic and regional anchors. So BIAC, as we all know, is also the host of the event along with SARCO. The premier and the first registered alternative dispute resolution institution, and mostly focusing on the domestic dispute resolution, and definitely promoting arbitration and mediation. I mean, for a long time, and they have really created a the situation where at least the people who are involved in commercial world in Bangladesh are very much aware and familiar with arbitration mediations than probably and 2 and 3 1 or 2 decades ago. So, and then comes SARCO. They're the host of this event. SARCO is a regional institution which is created by the statute, by a treaty within the SARC countries. So what their purpose is to deal with the arbitrations within the SARC countries, and they don't only deal with the arbitration between government within government, but they also do the private, like government versus private, private versus private. Their rule is quite open to deal with that. So what is their specialization? Definitely, they understand the regional issues. That's the most important. And of course, cost effective. If you compare with the very similar regional institution like ICSID, they're definitely much more cost effective, and regional accessibilities, understanding of the region, understand their complexities of the issues, historical issues, cultural issues. So all these are the advantage of SARCO. The other institution who are mentioning is definitely in this region is Mumbai Center for International Arbitration in India, and India International Arbitration Center. This is a new one. And in Pakistan, Center for International Investment Commercial Arbitration, CIICA, and in Sri Lanka, ICLP Arbitration Center. They are very much similar like BIAC, but mostly focusing on domestic. But I mean, depending on the parties' agreement, they can deal with the international cross-border arbitration as well. Okay, now my next slide is about the leading international framework for arbitrations for commerce, particularly, and investment. ICC, number one at present, they're dealing with the most of the cases focusing on complex multi-party infrastructure dispute, which we are not very kind of familiar with the local arbitration. We're adding parties, it creates complexity, but the rule have evolved into a situation that they can, add parties and also deal with, merge complex arbitration taking place between 2 and 3 separate arbitration into one. And the biggest advantage of doing an arbitration through ICC is their case management system. And they have a terms of reference. They define the dispute, issues of dispute first, and then they start the arbitration, and they have a court, but it's mostly facilitate the arbitration. And then the court, what they do after once the award has been passed, before the passing of they scrutinize it and kind of make it deals with the errors and something the institution should talk about if the arbitration, because the award need to be enforced. So that is a great role they play to make the award kind of very much suitable for enforcement. So, and then they have a strong case management system, and they try to minimize the dispute and also delay. They try to avoid the delay, and if necessary, I mean, they also confine the case within the time limits. So that's the advantage. The other key player is Singapore International Arbitration Center, SIAC. They're known for their speed and innovation, very much within our region. I mean, they're good for emergency arbitrations, expeditious proceeding, early dismissal. And it's for Bangladesh, it is related because, if you see the history of last 20 years, particularly the government contacts and major cross-border contract, we see the SIAC arbitration clause. Knowingly or unknowingly, parties are inserting it. I mean, because of their name and fame and the popularity within this region. And third slide about maritime and shipping. I mean, you don't see that the shipping cases are taking place in SIAC or SARCO, the institution we just discussed. The number one is LMAA. I'm fortunately very recently become a supporting member of LMAA, and they are definitely the number one in shipping and maritime related disputes, and there is no doubt about it. The panel not only include lawyers, but the panel also includes surveyors, brokers, mariners, and also, I mean, the rules are flexible. It's mostly ad hoc, but they kind of provide a strong support involving the shipping arbitration. And English law is mostly applicable, and in Bangladesh jurisdiction, you see the admiralty proceeding that we handle, where there is a charter dispute. Without any doubt, the LMAA is the chosen forum in the charter part, so it's by default goes there. Okay, so next one is Singapore Chambers of Maritime Arbitration. They are a kind of an alternative to LMAA. Not very old. I mean, it's probably they have been set up within this last decade, and they're trying to promote arbitration within our region, and also very small. Even it's not that big, but some the agreements we are finding the SCMA's name in the charter parties. So it's providing an alternative to LMA. It's for us is geographically near as an alternative to LMAA, and probably a little bit of less expensive than LMA. Okay, so disputes involving states. We see the ICSID, name of ICSID, and most of the government contract used to be using the ICSID, but nowadays it's not necessarily ICSID is used, particularly with investment contracts or sometimes with BIT, the name of this ICSID is used, and not necessarily so. ICC has been used, SIAC has been used, so but definitely ICSID is the place for investment disputes, and they, I mean, their power, the mandate comes from either from BIT or investment agreement within between the countries or between the investors and the host nations and or the agencies of the government. Their advantage is that compared with SARCO is very similar. They are also mostly focusing on commercial and investment disputes, but what it differs is that they popularize their institutional rules and their capabilities with the diplomatic support. So if an award is passed, and if you kind of get an execution award from ICSID and which required to be executed in Bangladesh, there are definitely procedural issues that we see, as we already heard from Honorable Justice Iman Ali sir and Abdul Rahman sir, that how the process is delayed. And we have handling a case recently on an execution where within the execution proceeding, one of the lawyer filed a section 46 application, which is basically you can only file as a separate application to annulment, to cancel the award because of it lacks like for example, there was no the biasness issues is there. There was issues of natural justice, but you cannot bring this application to the same court which is dealing with the execution proceeding in the same application. So that is happening. So there is a definitely procedural delay where the ICSID, what they do, they kind of has an enforcement mechanism through government to government, through diplomatic protection, through diplomatic channel. They take it forward and really help the the award the winner of the award to get it actually been executed or enforced. So this is something making them popular. So other than that, permanent court of arbitration, we Bangladesh a few times taken advantage of it. They mostly actually deal with the between government arbitration. They don't deal with private versus government. And famously, they have dealt with the Bay of Bengal Maritime Boundary Arbitration, uh, and not like the something suitable for these particular session we are discussing, because this is between government. So third, and SARCO's name comes again because they are the state entities formed by the state entities, and as I already discussed, that they have that cultural, the advantage, cost effectiveness, and familiarity of the region. Third type of arbitration, which are not commercial or investment or shipping things, which are it's very much the today's topic, like WIPO Arbitration and Mediation Center is one of the center who deals with the IP and information technology related disputes. And I haven't heard that or haven't had the opportunity to deal with this kind of arbitration yet, or I haven't found any clause, but they are kind of definitely the leaders in they have this specialized panels for patent, specialized panel for software licensing, data privacy, and it really requires a specialized knowledge to deal with IP or IT related arbitration. So they are the unique setup they have, and they are kind of very much have the ability to deal with this kind of arbitration. Other notable global institution, Hong Kong International Arbitration Center. Bangladesh, we don't use in our arbitration clause. HKIS is not that much popular as yet, but we do have Singapore investors from China, and then HKIS is mostly used as an alternative to kind of CR as a competitor, and particularly investment connected with China or cross-border trade and disputes involving Chinese investors, Chinese parties. HKIS, is the place, and then other than that, LCIA, very old, and they use the English law. That is one of the advantage, and also the another difference with the other institution is that they don't determine the cost of arbitration with the percentages or value of the claim. They decide the arbitration, the cost, kind of the expenses based on hourly rates rather than the value of the dispute. Okay, so what we are kind of taking away from this particular institutional ADR in Bangladesh, the topic is that, where do we fit in that? We have to understand first. BR is playing a great role in growing arbitration, and particularly with awareness. And I had the opportunity to be the very first lawyer for the very first claimant under the BR rule, the very first arbitration under the BR rule, where Mr. Mail Senior, Mr. Azmalul Hossain was the sole arbitrator. And it was about an investment arbitration within a export processing zone in Bangladesh. So it took only 3 months to get the arbitration award. And then we have filed the execution, and that execution also went well by taking time, but we fortunately able to bring some success in the execution. There was a local parties was involved, and we are able to find assets and also put the assets that process is going on. Trying to sell the assets through execution court, Honorable Learned District Judge. So, but what the BIAC is need to be probably focused on, work more on, is that their panel is not very rich. I mean, they'll have to expand their panel. They bring more expert the people in the panel, local and international. So an institution get its advantages, get its kind of familiarities from the perspective of clients or those who use the arbitration. Is they first look at the panel, who are within their panel, and what kind of specialized panel they maintain. So if they want to be competitive, they must not only expand the panel but also prepare a specialized panel, or they could put one or two tiers of panel, like panel of arbitrator, list of arbitrators, as we see in CR. And other thing they should work on is find out the scope of arbitration they should be dealing with. So according to me, they should be the first choice for domestic arbitrations and also mediation, as Imal sir was referring. They can introduce made-out clause. The reason mediation is not happening is number one is problem of awareness, and second problem is that in the clause, the clause that we used to be inserting as a law firm in the agreement, we depending on the parties involved, location, we decide which clause should be inserted. So if it is like two locals, we always put BR clause. But problem is that we didn't put the made-out clause before, because that was not there. So they have introduced it. So if you put made-out clause, then mediation will be the first thing we should be trying. So the very first arbitration we did, it was not made-out clause. It was just an arbitration clause. So, I mean, that is, also a role of the law firm. They should also try to promote the arbitration and mediation, because definitely, as we already had a first-hand experience, that we get an award from BR within 3 months, and then we executed it, and it took 2 years to almost, we are about to get the assets and get it liquidated and kind of provide the ultimate relief for the client. So that's one thing for the BIAC. And for SARCO, probably, the advantage they definitely have. I'm pretty sure they're working on it. Try to focus more on not only getting an award and then execute it, but probably diplomatic support they can easily get from all SARC countries. So if there is an award from SARCO, the diplomatic channel will try to enforce it in whatever the capacity they can. So that is something they may focus it and popularize their arbitration rule or arbitration institution in that way. And also the regional knowledge and expertise, as they also do a lot of activities in other countries within the SARC, and they definitely have the expert knowledge and understanding of each region. And there is no doubt that if a SARCO clause, if it is inserted within an agreement, for example, between India and Bangladesh, between two commercial private parties, particularly involving trade or could be investment, if SARCO clause is inserted, I'm pretty sure that will be a wise decision. So, I mean, end of the day, there is no single arbitration institution who can support all. Okay, so there are regional player, global player, and there are local players. So they need to understand where they fit in and where they where they should provide their service or promote their service. I mean, for example, if we are compete with LMA, that definitely not going to practical. So parties is probably not within 10-15 years is going to choose BR clause for shipping dispute. So focus should be on institutional arbitration should be on for BIAC will be probably investment, probably on commerce, commercial matters, trading matters. We have a lot of issues, particularly with commercial disputes. If it is involving sales contract and supply of goods under the sales contract, either with or without LC. So even within two domestic parties, there is an LC where they have taken some supply from a local customer, and then there was non-payment, and that we have dealt with few cases which took 12 years to get the first-hand judgment from district court, and that dispute could have been resolved within 3 to 6 months to probably maximum 1 year. So that is the unique the scope for BIAC to focus on, like commercial dispute within Bangladesh territories. So nothing much from me. Thank you so much for SARCO and BIAC for giving me the opportunity to speak in before such a great gathering. Thank you. Assalamu alaikum.
Thank you, Mr. Rahman, Farooq sir, as I call you. Thank you for the very important recommendations and the mention as well. I won't go too much into it because you've already covered the institutionalization of ADR very comprehensively. But just to add maybe 1 or 2 points, we completely agree with the recommendations that you suggested. With regards to leveraging our own capacity in terms of cultural sensitivities, we do have panels from every member state from the SAARC region. So Bangladesh has a panel, Bhutan has a panel, Sri Lanka has a panel, Pakistan. All the countries have individual lawyers on separate panels. And that we could use and leverage in terms of our strengths. Also the diplomatic channels, we do use that, utilize that, and that is one benefit that we have in terms of our mandate. And obviously our mandate is not only just to deal with cases, but also strengthen national institutions such as BIAC or such as Bhutan ADR Center or whichever ones we have worked with in the past. That's always been part of our mandate. But we are working towards improving this more. For example, in 2026, we are planning to have roundtable conferences with a number of high-level governmental officers, judicial officers, just to see that how can we more improve not only our system, but the system of that specific country as well. Inshallah, that will come when we reach that point. But we are thankful for all these suggestions, and we do take these into account and then also make it part of our records. And of course, we do continue to do follow-up activities. So maybe hopefully next year, following up on these suggestions, we can also maybe see where we are at that stage. So thank you once again, folks. We'll now move on towards our third thematic session, which is titled Cross-Border ADR and Regional Opportunities. It is my pleasure to introduce Barrister Saqib Mehboob, Advocate of the Supreme Court of Bangladesh. I've had the pleasure of meeting Barrister Mehboob last year in the same conference, which was organized in collaboration with BIAC. So just to say a few words about Barrister Mehboob. Mr. Mehboob has over a decade of experience in dispute resolution, arbitration, corporate law, and merger and acquisition work. After beginning his career at Huck & Company, Barrister Mehboob joined, or I would say formed Mehboob & Company in 2013. We have since played a key role in transforming the firm's dispute and corporate practice. He has led high-stakes arbitration matters, including SIAC proceedings involving global companies such as Johnson & Johnson, as well as construction disputes on behalf of international contractors and state-owned entities. He also appeared as counsel in a landmark Supreme Court case that established the legal basis for virtual AGMs of listed companies, directly leading to regulatory reform. Alongside his arbitration practice, Barrister Mehboob heads the firm's corporate and M&A work with a particular focus on foreign investment and technology. He has advised multinational clients on structuring, tax efficiency, and employment issues, and has successfully guided several cross-border investments in Bangladesh's growing tech tech sector, including e-commerce and online learning ventures. Besser Mehboob, thank you for joining us. And now I'll now pass on the floor to you.
Thank you, Mr. Saqib. It is a pleasure to see your face again. It was a pleasure to see you last year, I think in Dhaka. I had the great opportunity of attending and speaking at the SARCO event in Dhaka. I'd just like to correct one thing about my introduction. The farm Mahbuban company was actually formed by my father, Mr. Mahbubuddin, back in 1995.
My apologies for that.
No worries, no worries. So it is a pleasure and honor to be on the same panel as Mr. Justice Amy Manali, Mr. Justice A.F.M. Abdul Rahman, my very dear respected senior colleague, Mr. Farooq Rahman. They have covered a lot of issues that don't need repeating. So I will actually skip, and since in the interest of time, I will skip an overview of the cross-border aspects of ADR in Bangladesh and the region, and instead I will try to go look at a couple of case studies. But before that, I would just like to respond to a comment from the honorable judges on this panel that lawyers don't like ADR. I would like to say that I am actually a lawyer who is a fan of ADR. I actually love arbitration. And one reason is that growing up, when I wanted to become a lawyer, I thought cross-examination was the height of excellence that a lawyer could reach. And I have been fortunate enough to perform cross-examination, to conduct cross-examination in a few arbitrations. Unfortunately, none of my commercial litigation cases have yet reached the stage of cross-examination, let alone judgment. In my short career of 15 years, I have not yet could reach a stage of cross-examination in any litigation matter, but in arbitration matters, I have been able to conduct cross-examination, which has been an absolute pleasure for me. So I am a very big fan of arbitration, and I would favor it over litigation any day. I also want to respond to another an issue of arbitration versus mediation, and I think this kind of segues into what I was going to say, and perhaps I would start with the New York Convention and the power of the New York Convention and the impact that it has on ADR in the world of business and commerce, since we are talking about business and commerce. So obviously, the purpose of dispute resolution is that there is finally a judgment or an award or a settlement or whatever, but that it must be enforceable. And the New York Convention, what it does, it provides the award a kind of a visa-free access to about 172 countries in the world. If there is an award that is passed in Bangladesh with Bangladeshi council, Bangladeshi judges or retired judges or Bangladeshi arbitrators sitting as in the arbitral tribunal, and an award is passed, that arbitral award is actually enforceable in 172 countries, and that includes almost all developed world or the Western world, Eastern world, all countries that you can think of, and which is not possible with litigation. With litigation, you need a reciprocal treaty, which Bangladesh does not have with most countries in the world. As far as I know it, there is only a reciprocal treaty with India and no other country in the world. Please do correct me if I'm wrong. So if there is a award that is passed in if there is a litigation judgment in Bangladesh, it will against a party who is based in the UK or the South Africa or China. There is absolutely almost no way to actually take that judgment and enforce that against that party in the UK, South Africa, or China. Whereas an arbitral award passed in Bangladesh has that access to those countries. It is possible to go and directly enforce them and if there are assets of the losing party in those countries, those can be made part of execution proceedings as well. So for trade and commerce, the New York Convention plays a huge role, which is unmatched by litigation and is actually unmatched by mediation as well, which is why I wanted to mention the arbitration versus mediation, because there is anything similar to the New York Convention, anything equivalent would be the Singapore Convention on Mediation, which is a much more recent convention and treaty, but only about I checked last, only 59 countries have actually signed that treaty, and unfortunately Bangladesh is not one of them. So a mediation settlement in Bangladesh does not have the access to anywhere in the world. Although within those 59 countries which have signed, India included, I believe, and I don't know if they're regionally, if there are other countries, please, Mr. Saqib, if you may correct me if Pakistan has joined or any other country in SARC has joined, but not many countries actually have joined the Singapore Mediation Convention. So in that sense, arbitration comes out as a very efficient tool, as a first choice for cross-border commerce and trade, and that is because of the New York Convention, which allows this sort of visa-free, as I like to call it, a visa-free access to 172 countries in the world. So as I said, I would not like to go into too much of the overview, but go into two case studies. So the first case study is actually, and both the case studies are case studies that I am actually, these are cases that I am actually involved in right now. So I thought this would be easiest for me because I could actually speak from experience, and it would also cut down my preparation time. So the first case study is what happened is that a Bangladeshi garments manufacturer gets an order from a South African company to produce some garments and sell it and send it to South Africa. And the South African company verbally says to the Bangladeshi garments owner that you should get your fabrics from a particular supplier in China, a fabric supplier in China. So what the garments owner does is that he opens an LC with the Chinese fabric supplier, and he imports the fabrics from China. The fabrics arrive, and the Bangladeshi garments owner immediately thinks that the fabrics that he has received are not up to the mark. So what he does is that he speaks to the buyer's agent, the South African buyer's agent based in Dhaka, and asks him if he should accept the fabrics. The buyer's agent says, yes, okay, you accept the fabrics, no worries, no problem. The buyer will accept the clothes that you make with these fabrics. So the Bangladeshi garments owner then makes the garments with those fabrics and sends them to South Africa. Unfortunately, the South African buyer rejects the garments on the basis that the fabric is not the correct fabric, or it is of substandard. It is not the correct standard. So then this Bangladeshi garments owner has two disputes at hand. One is the dispute with the Chinese supplier, the fabric supplier, because the fabric supplier has supplied faulty goods. And he has a dispute with the South African buyer, because the South African buyer has unjustly refused taking the goods even after his agent had promised that those goods will be accepted. Unfortunately, and this is all cases that I will see in the garment sector, which is the biggest export earning sector in Bangladesh, that there is no arbitration clause in any of these transactions. Absolutely nothing. None of them will have an arbitration clause. I have not yet seen any of the Bangladeshi garments owners even asking for arbitration clauses. And this being such a huge sector for Bangladesh, and this sector is completely out of the purview of ADR so far in Bangladesh. So what happens is that he's now suffering because he imported the fabrics from from China with an LC. So he has to make the LC payment. The bank will send the LC payment any day. And he cannot recover. And the only way for him to go and sue the Chinese supplier is to actually go to China, file a suit in the Chinese court, appoint Chinese counsel, which is very intimidating for him. Another thing that he has to do or can do is to go after the buyer who is based in South Africa. Again, there is no arbitration clause. So, and the South African buyer has no presence in Bangladesh. So he has to go, in order to get any result out of this, he has to go to South Africa and appoint South African counsel, go to the South African courts. He doesn't know whether actually it is even possible. So this is a perfect case of when arbitration could have actually, an arbitration clause in either of those contracts could have actually saved this person or given this person an avenue at least to get some justice, to get an adjudication at least. And then with that adjudication, if there was at the end of that adjudication an award in his favor, that award would have been enforceable in both China and South Africa, which are both New York Convention countries. So they would have, if there was an arbitration in Bangladesh, that even that arbitration award would have been enforceable in China, and it would have been enforceable in South Africa as well. So that is one example of where we are really missing out. This huge sector in Bangladesh that does not use the power of ADR, the power of the New York Convention at all, even though most of the buyers that get into disputes with Bangladeshi garments manufacturers are based in countries that are New York Convention countries, the UK, the US, all European countries that buy from Bangladesh are New York Convention countries. But this amazing opportunity is not taken care of. Since the topic that I was given was of opportunity, I thought this was something to really point out, that there's an opportunity that we are really missing. And I think that the garments sector should be approached. It should be brought under, it should be made aware of the power of ADR. It should be made aware of the benefits of ADR, how efficient it is, and in fact, there is no other option. Actually, litigation is not an option. So even mediation is not an option. Arbitration is there. The New York Convention is there. So absolutely, why not use it? So I'll leave it at that. And that's my first case study and I will not say which side of that dispute I am on, but I am representing one of those parties. And it is a dispute that has no end now, because it's basically it's quite a big mess, because there is, though there are court cases, there is no prospect of this case going anywhere or it being enforceable at any point of time. Anyway, another case study I want to talk about is a recently concluded matter, and this is actually to point out a gap in our law. In the Arbitration Act. The Arbitration Act of Bangladesh is modeled under the ancestral model law. However, it has various gaps which have been covered by ancestral later on in the ancestral model law revisions. And other countries who did follow the ancestral model law have done those revisions in their laws, but unfortunately, Bangladesh has not gone there. And I'll speak of how that affected a particular case. So this case there is a Chinese and Thai joint venture. A Chinese company and a Thai company are in a joint venture, and they are implementing a project in Bangladesh. And they have an arbitration clause in their contract, and that arbitration clause stipulates SIAC arbitration in Singapore. So it's a very international kind of transaction where the work is in Bangladesh. They have a JV company which is in Bangladesh, and the two parties which form the JV company are, one is Chinese and another is Thai. And they are between them, they have an arbitration agreement which stipulates in a case of dispute to go to SIAC in Singapore. So there is a dispute. A dispute arises because one of the parties, the Chinese party, wants to is triggering a clause to take over the shares of the Thai party, which it is allowed by contract to do. And so it tries to do that. And in that case, the Thai party immediately goes to SIAC and files an arbitration. But in the meantime, since the shares are in Bangladesh, the Thai party also files a application under Section 7A of the Arbitration Act to get an injunction against the transfer of the shares. So initially, the High Court, which is the court given jurisdiction under Section 7A for an international commercial arbitration, the High Court passes an interim order of injunction or status quo. But after a long hearing and after considering a lot of judicial precedents and the Arbitration Act and the purpose of it and the definitions under the Arbitration Act, the High Court decides that actually the Section 7A application is not maintainable on the basis that the Arbitration Act of Bangladesh is only applicable to arbitrations that are situated in Bangladesh, which are happening in Bangladesh. So if there is an arbitration between two parties, one of them may be one party may be Bangladeshi or two parties may be non-Bangladeshi, regardless, the arbitration, if it is happening outside of Bangladesh, if the seat of that arbitration is outside Bangladesh, then the High Court does not have any jurisdiction to pass an interim order. And that is regardless of the fact that the subject matter which is in dispute, in this case, the subject matter in dispute were the shares of a company in Bangladesh. Even then, even when the subject matter of the dispute was situated in Bangladesh, the High Court said that we don't have any jurisdiction over this matter because the Arbitration Act says, Arbitration Act of 2001 says that the Arbitration Act is only applicable to arbitrations happening in Bangladesh. And that was the judgment. And this is currently there are different judgments and different interim orders that have been passed by the Honorable High Court Division in Bangladesh. Unfortunately, there is not much clarity. There is divergence, a lot of divergence. Some courts have exercised jurisdiction under Section 7A to pass interim orders, even in a foreign stated arbitration. Some courts have refused to do that. But now the last judgment, I think this is the last major judgment that has come, where the court has said that we don't have any jurisdiction to pass a interim order under Section 7A, even when the subject matter is in Bangladesh, if the arbitration is situated outside of Bangladesh. So this is a big problem when it comes to, because in international trade and commerce, it is often will be the case that when there is a Bangladeshi party and another foreign party involved, they will choose a neutral venue or a venue that is outside of Bangladesh at the very least. And in most cases, that venue will be Singapore, and the institution will be Singapore International Arbitration Center. So in that case, in all those arbitrations, even though the contract is being executed in Bangladesh, the subject matters will most certainly be in Bangladesh. The Bangladeshi courts will refuse to exercise jurisdiction to pass an interim order, and this will have a very bad negative impact on parties which do business with Bangladeshi parties, which are investing in Bangladesh, because they will think that when they're investing in Bangladesh, they have an interest in Bangladesh. Those interests will not be protected by the Bangladeshi court because they have chosen an arbitration institution or arbitration venue outside of Bangladesh. So this is something that the Indian courts actually had to decide and address for the whole of the last decade, for the 2010s. And finally, there was an amendment, I believe, to the Indian Arbitration Act, where it finally decided that, okay, we have had judgments on both sides. Now let's settle it for once and for all and put it in the act that the Indian court will have jurisdiction over a subject matter to pass an interim order, even if the arbitration is seated outside of Bangladesh. And we still have that gap, and which will cause a big problem for us if it is not because now there is a definitive judgment from the High Court division, even though it is not confirmed by the appellate division. The matter did go to the appellate division, but it was later non-prosecuted for different reasons. So there is no appellate division confirmation on that position. But this is if I give an opinion today to a foreign party, I will have to refer to that High Court judgment and say that this is the Bangladeshi position, Bangladeshi court's position. So you will not be able to get a interim order if your arbitration is situated outside of Bangladesh. So in closing, I would like to say that considering the two case studies, that first of all, the arbitration under the New York Convention is not just an abstract legal tool. It provides real enforceable protection across borders that courts simply cannot match. There is no way a court of any country can match that level of access. And secondly, there's gaps in our legal infrastructure which need to be filled. The inability for a party to obtain interim relief where arbitration is outside of Bangladesh, it actually translates into losses for Bangladesh's economy, for Bangladesh's exporters, importers, investors, everyone. And if Bangladesh wishes to truly play in the big league of global trade and high volume sectors, we have to empower our businesses to use arbitration intelligently and reform our arbitration law to meet the global best practices. Thank you very much, and I hope you enjoyed my little speech.
Thank you, Mr. Mehboob. Very interesting insights, real life examples. Always strike a chord with us as well. The second example that you gave was very interesting, and I'll have to check our own law, Pakistan law. What does that say? Because I don't think I've come across that kind of situation, at least in our jurisdiction, but because we have also not updated our laws since 1940s. Ours was also based on the UNCITRAL model, and since then, obviously, there have been too many revisions, which institutional wise, there have been revisions, but from a legislation perspective, national legislation especially, I'm not sure. So that's something very interesting for us as well. With regards to your query on the Singapore Convention, on the top of my head, I know for a fact that Pakistan is a signatory, and Sri Lanka, I think, is one of the first signatories. But for the rest of them, I'm not very sure about that. But again, thank you for the very knowledgeable information and the examples that you gave. And I'm sure this will also help us make ourselves better as well. Ladies and gentlemen, we have heard from all of our speakers. I'd now like to invite the participants, or rather the audience members, to put their questions in the chat, and we can ask the esteemed the guest speakers to answer them. I understand that we have already received one question for Justice Iman Ali, sir. So if you're still with us, I can refer it to you.
Yes, I see the question. And my simple answer to that, the question regarding the standards of accreditation and of mediators and arbitrators. Well, the standard, obviously, of any person who takes instruction from any institution is up to the institution itself. So it is for the institution to maintain their standards, and it is for the institution to give the accreditation. So, for example, if BIAC imparts with teaching arbitrators and mediators, well, not teaching, training arbitrators and mediators, then it is up to BIAC to keep the standard of the training that it gives out to the arbitrators and mediators that it trains. I remember that when we were training the judges, the lawyers, particularly in Bangladesh, on mediation, it was something very new. Obviously, mediation, arbitration, it is still in the nascent stage because it hasn't been there for long enough. Particularly, it has not been utilized for long enough in Bangladesh. But when we have institutions imparting knowledge, when we have institutions imparting training, it is up to the institutions to keep up their standards, and it is up to the institutions to give the accreditation. We have very sort of old institutions in the UK, for example, which give out training for mediators and arbitrators, and they are very well recognized across the globe. So if and when Bangladesh has an institution which is accrediting the lawyers, the judges, whoever it is accrediting as mediators and arbitrators, then that will be the institution which will be recognized worldwide. It is as good as it is. If BIAC, for example, becomes a good recognized institution for training arbitrators and mediators, then it will be recognized worldwide. So how to maintain the standard? Well, you have to have internationally recognized trainers. When I was training lawyers, particularly on behalf of BIMS, we had trainers from India, Africa, across the globe, America too. So I believe the training we were imparting was of international standards. And that is what you need to do in order to maintain credibility of the institution itself. I hope I have answered the question which was posed.
Okay. Thank you, sir. Who will be the regulatory? How the standards could be and should be maintained, how they should be accountable for their actions, and who will be the regulatory authority. I'm not sure, sir, if you could also touch upon these points. Who could be the regulatory authority?
Well, for maintaining standards, the regulatory authority must be the institution itself. And it will depend on how good they are and how good they maintain themselves, how well they maintain themselves, because in future, any person who shows up as not a good arbitrator or a good mediator, it will be bad reputation for the institution itself.
Okay. Thank you, sir.
I mean, I could say the regulator should be the Supreme Court, but then, that is burdening the Supreme Court with something else which is, not within the purview of litigation.
Thank you, sir. I think we can move to the next
Abdul
question.
Rahman is trying to say something, but again, he's muted, so we can't hear
Sir,
him.
if you could unmute yourself, sir. Yeah, sir, we can hear you now.
Can you hear me? Yeah. So what we have seen that only the lawyers are being engaged as arbitrator, no other person. If other persons are engaged, they do not know the law, they do not know the procedure, but they act as an arbitrator. So, same thing with the lawyers. But so far the question of retired judges come, then what happened? They know the law. The retired judges from the subordinate judiciary or from the High Court Division or Appellate Division, they know the law. So they can conduct the arbitration very nicely. But so far, the layman is concerned, appointed as an arbitrator, he doesn't know law, as his Lordship Mr. Justice Emmanuel has said, that he should know the law. So my proposal will be, there should be regulatory authority. Now all the arbitrators are independent practitioners. They have got nothing. People know that this man is an arbitrator. So he choose him, yes, you be my arbitrator. But if there is a regulatory authority under the government, regulatory authority who will enroll the arbitrators, and from that panel, the arbitrators will be chosen by the parties. Then the inter-arbitration system may come to a regular method. That's my proposal.
May I just add here that under the law in Bangladesh, the Code of Civil Procedure, I think it's section 89A, subsection 10, there is a provision for appointment of having a panel of mediators, and that can be from judges, lawyers, and others. According to the panel will be chosen by the district judge and the president of the local bar. I think, if I'm not mistaken, it's a long time since I dealt with this.
Yeah, that's correct. That's correct.
And I think in the end, initially there were no panels created by any districts. But we then issued a circular saying that the district judges must, in accordance with the law, create a panel. And in the end, we managed to get, I think, 41 districts to actually create panels of mediators. So again, there is the possibility of creating bodies to make these panels. But then again, as I said, the quality of the panel will depend on the training imparted to the panel members. And with all due respect to Justice Abdul Rahman, the issue of having outsiders, meaning non-lawyers as members of the panel or as mediators, is that there may be persons who are efficient or proficient in other fields, for example, bankers in banking, engineers in engineering. So there is no reason to preclude them from becoming arbitrators or mediators. In fact, there will be an advantage of having those as arbitrators, mediators, so long as they are given the training in law as well, because they will be dealing with legal matters. So it is up to the institutions imparting the training to ensure that the arbitrators or mediators are proficient in what they're going to be doing in the future by way of mediating or arbitrating.
And my proposal, that has to be done by a regulatory body.
Okay, thank you, sir. I think we can move on to our next question. So the second question is from Mr. Aminul Hassan. How can ADR be made more cost-effective and accessible for small and medium enterprises in Bangladesh? Farooq, sir, I think if you could maybe, or anyone amongst the guest speakers, because this is not addressed to any specific person.
It's a difficult question. Because this is the one of the lacking of the arbitrators, that they charges high fees, irrespective of the work, irrespective of the dispute, the gravity of the dispute. The chairman used to charge 20. The arbitrators used to charge 10, and the other fees are 5. So it's so high charges that people are detracts from the ADR, from the arbitration. But to reduce it, it's a difficult question.
This is where I think mediation wins the game, because mediation you can have it done for free or at a very little cost. But again, it's up to the parties to know what they want to do. Mediation is something that has not taken effect in Bangladesh particularly. And I think the main reason behind that is lack of knowledge, lack of understanding of benefits of mediation, or indeed arbitration. You see, if you go to sort of private individual lawyers for arbitration or setting up an arbitration, they will be charging a lot of money. But then if you go to some institution, like BIAC, for example, they don't charge as much. They have specific set down fees, which are, I think, more reasonable than the privately set up arbitration. So, but then again, having said that, with tongue in cheek, I can say that perhaps BIAC would not attract highly demanded arbitrators if they're going to pay measly fees in the eyes of the arbitrator. So if they pay lower fees, then they'll expect somebody who's not so highly demanded as an arbitrator. So these are the pros and cons. You have to meet those things in the middle somewhere. But I go back and say mediation is a better.
Thank you. I think, yeah, that's a catch-22 for us as well. Like, what kind of fees should we set for the arbitrators, for the center to have the right kind of cases?
I just want to add one thing. You know, as no, in SIAC you'll see that they have a 3-4 list. Okay, number one is panel of arbitrator, then list of arbitrator, then they have another panel. They don't publish it. It's like emerging kind of or those who are interested in arbitration, they have a list of like that. Okay, so an institution can minimize the cost by preparing more than 1 tiers of arbitrators, and also kind of make a range. Probably the highest panel will have the more ability to charge more fees, and then to make it cost effective for SME, they could put a kind of economic version of list of arbitrators. So I don't think there's nothing wrong in that. Like lawyers or having 5 years experience and having degree in arbitration, or they can be put in those panel, and they definitely will be interested in to doing their first arbitration. So nothing wrong in that.
Thank you,
Thank
sir.
you.
So we have a next question from Mr. Tenzin Liwan. So Tenzin Liwan is one of our old collaborative partners. He's also the chief administrator of the Bhutan ADR Center. So his question is that why do you think that Indian court granting interim relief in a case which is seated in another jurisdiction is a good example for us, because parties never submitted to the jurisdiction of Bangladeshi courts in your second example? I think this question is for Barrister Mahbub.
Okay.
Sorry, which question was that one? I see a couple of questions in the chat
Mr.
box.
Tenzin, the one from Mr. Tenzin Liwan. Why do you think the Indian court granting interim relief in a case which is seated in another jurisdiction is a good example? Because parties never submitted to the jurisdiction of Bangladeshi courts in the second example that you gave.
Okay, so I think why that option should be open. Obviously, it is on a case-to-case basis, and the court should not assume too much more than the jurisdiction it actually has. But why the option is important is because if there is a contract where the subject matter is in Bangladesh, but the parties feel that they would have a better dispute resolution in Singapore, they should be allowed to do that. If there is say a Bangladeshi party and an Indian party in a contract, the contract is to be for works to be done in Bangladesh. Even then, the Indian party may feel that it wants to have its dispute resolution outside of Bangladesh in a neutral country. So, and often in the region, if there's a contract between two different parties from two different countries, they would go for a neutral country, for example, Singapore. So now when they have submitted to Singapore and the seat of the arbitration is also Singapore, they have selected SIAC as the institution. But the problem remains is the contract is still to be executed in Bangladesh. And the issue is that the subject matter of the contract may be in Bangladesh. Now, Section 7A is there to protect the subject matter of the contract. So there is no subject matter existing in Singapore. There is no subject matter existing in India or any other country. The subject matter is in Bangladesh. So in order to protect that, to preserve that subject matter, the Bangladeshi court has to have that power. But unfortunately, currently, in a situation where there is an Indian company with a Bangladeshi company, work done in Bangladesh, Singapore arbitration, there is no way for Bangladeshi court to assume that jurisdiction and preserve that subject matter. If the subject matter cannot be preserved, the parties will also not be willing or interested in going for that arbitration, because by the time that arbitration is over, the subject matter may be destroyed, it may be consumed, it may be of no particular importance by the time that arbitration is over. So arbitration would be fruitless. So no one will pay money for a fruitless arbitration. So in order to give that arbitration that strength and that basis, the subject matter has to be preserved. So in order for that to happen, the court of the country where the subject matter is has to have the jurisdiction. And that is my opinion, and that is why countries have gone to that. And this gap has been filled in several countries where this was a gap in the law at first, but they have then filled that gap and created the scope for that for the courts to then exercise jurisdiction even when there is a foreign seated arbitration, provided that the subject matter is in the jurisdiction of that court. So if subject matter is in Bangladesh, my argument and my submission is that the Bangladeshi court should have the jurisdiction to then have to pass an order on that particular subject matter.
Thank you, Mr.
Yeah,
Mehboob. Sir, did you have
If
one?
I may add to that, if you'll excuse me, if I may add to that, I remember there was a case when I was in the High Court Division, presiding the company bench, of Piermont Power, I think it was, or one of the parties was Piermont Power, and I believe Mr. Azmarul Haq, Azmarul Hussain Casey was one of the lawyers engaged, and the matter was going on in Singapore, in London, as well as in Dhaka. And if I'm not mistaken, we did pass an interim order, but that wasn't anything to do with arbitration. Now, having said that, I believe, agreeing with Sakib Mahboob, that if if it becomes necessary to pass an interim order within any jurisdiction, because the property happens to be in a certain jurisdiction, the court should have the authority to do that. And if the Arbitration Act is a bar to that, then I think the Arbitration Act should be amended to facilitate that. Otherwise, you defeat the purpose of the litigation in the first place. So in other respects also, I believe the Arbitration Act needs to be changed. More particularly, I believe the New York Convention should be incorporated into our law so that we can enforce awards under mediation or arbitration. You mentioned the lack of inability to enforce decrees in any country other than India. If I'm not mistaken, before 2003, this Code of Civil Procedure allowed decrees passed in England to be enforced in Bangladesh, or vice versa. But then the law was changed in 2003. And again, I think now we are a global community. It should be possible to enforce any decree from any country within any other country. So again, change of law is necessary to meet with the needs of the time.
Thank you, sir. Speaking of change in law being the need of time, the second question is, do you think Bangladesh should have a separate mediation act or a separate act for foreign investors or investments? The question is addressed to Barrister Sakib, but Justice Manali, sir, you could also maybe touch upon the mediation part of it.
Yes, indeed, I do believe that we do need laws, particularly rules regarding mediation process and procedure, so that there is uniformity across the board. And if we follow, for example, the international rules on mediation, as we do for international rules on arbitration, then you cannot go wrong, because then there will be uniformity across the globe, so that lawyers in another country do not find the rules in Bangladesh to be alien. If we have similar rules across the board, then there should not be any confusion.
Thank you. Barrister Mehboob, would you like to add anything to this?
Just that there is actually a law on foreign investment, the Foreign Investment Protection and Promotion and Protection Act of 1980. And it's that covers that quite the sort of broad foreign investment issue of it covers like equitable treatment for foreign investors, which is covered in most bilateral treaties anyway. So it's not something that I would say is a pressing issue, but for mediation, definitely I think Bangladesh should become part of the Singapore Mediation Convention and have enforceable mediation. So that would really give the mediation sector a big push. If mediation settlements can have the binding effect that an arbitration award does, then it will have a huge impact on businesses then being motivated to use mediation. Because at this point, even if there is a settlement after mediation, that settlement then is a simple contract. And that contract, then if you want to enforce that contract, you have to go through the civil court process again. So it doesn't, if one of the parties then says, I don't want to abide by the settlement that I have just gotten into, the way to enforce that is to go through the civil court process again. So if Bangladesh does become part of the Singapore Mediation Convention and and has an act which can be part of, it can be an amendment to the Civil Procedure Code as well, doesn't need to be a separate act, but which will give effect to a mediation settlement and will carry the same status as an arbitral award, then it will certainly have a huge impact on the growth of mediation in trade and commerce in Bangladesh.
Thank you.
May I just add here, I'm sorry to interrupt you again, if I could just add, the provisions for mediation are scattered all over the place. So you have mediation provisions in the CPC, you have mediation provisions in all different statutes, so many different statutes. And I would strongly recommend a specific mediation act so that all the laws in different statutes can be incorporated into one place for ease of reference at the minimum for the lawyers and the persons who are involved in the mediation.
Thank you, sir. Farooq sir, I have another question for you. It's from a third-year law student at Daffodil International University. My question is that being a third-year law student, how can I prepare myself towards the path of ADR as a career?
I think Abdul Rahman sir is definitely the better person.
What is the question? What is the question?
So the question is that being a third-year law student, how can I prepare myself towards the path of ADR as a career? So how can I choose ADR as a career for myself, for example?
Oh, yeah. First, you have to be a lawyer. You must be a lawyer, because only the lawyers are trusted people to the parties who can appoint you as a mediator. So be a lawyer first. Then, if you want to be a mediator, be a certified mediator. There is provision for certified mediation, and become a certified mediator. Then you can get the opportunity of contribute to the field of mediation. So from the very beginning, when you are a law student, from the very beginning, you make yourself prepared for the profession of a mediator. And if you can prepare yourself as a good mediator, then so far my Lord Mr. Justice Amanali has said that if the mediation became the only ADR, then you will have every opportunity to be a mediator. But mediation is such a difficult subject, because the parties, they say, if you can mediate, then why we come to the court? That is the only saying of the parties, that we cannot mediate. Since we cannot mediate, so we have come to the court. If we could mediate ourselves, then we will not come to the court. So the great difficulty in mediation matter, I did some mediation, 1 or 2 mediation. Everywhere the party says, no, we cannot do it because we cannot. We will not talk to the other party. They are saying they will not talk to the other, because District Judge Dhaka, he has appointed me in some mediations. I brought the parties, and I talked to them. They said, no, I will not talk to the other party. So this is the mentality of the parties in respect of mediation. So mediation still it's not a growing subject in Bangladesh, rather than the arbitration.
So just to add to that,
Sir, I want some your comment on the matter. What I have said.
Oh, you want comment from me?
Yes, sir.
If you want comment from me, then I'll have to tell you about the dream that I had of expanding the field of mediation to the villages. Because if you can tell the people concerned, the litigant public, they don't come from the towns much. Yes, in the business context, yes, they do. But otherwise, most of the litigation comes from the villages, from the grassroots level. So if you can tell the people in the grassroots level that mediation is a good, beneficial process, cheap, quick process, and a process which will lead you to retain your peace within the community. And if you can show that the system works, then they will turn to mediation. But at this moment, they go to a lawyer, and the lawyer says, forget mediation, we'll go to court, we'll win. So I think at the end of the day, it is the litigant public who has to realize the benefits of mediation, or arbitration for that matter, And that you can
Exactly.
only do by example. So if I can take the mediation through the legal aid officer to the union council or to the the police station or Thana level, then people will see the benefits. That they can go, they don't have to go to the district level, they don't have to go to the court, but they can resolve the matter at the union level or at the Thana level without any expense through the legal aid officer. Then I believe mediation will take off. And there, what you need is publicity about mediation, publicity about the benefits of mediation, speed, cost saving, simplicity, informality, confidentiality. All these are benefits which the public will go for if and only if they know they know about it. And how will they know about it? Through TV, through media, social media, and through word of mouth. If Joe Bloggs will tell his neighbor that I went to mediation and got it done in a few days or a few weeks, then his neighbor will know exactly the same. I mean, I dealt with a case in the appellate division. It wasn't a civil case, it was a criminal case. The criminal case arose as a result of some cattle eating paddy. And they had a dispute, they had a fight, and it was a criminal case, Section 324, I believe, if I'm not mistaken, which went all the way to the appellate division. And I was really cross. I was really very angry about the whole system, whole situation, because why should a case under 324, I think it was 6 months imprisonment, go all the way up to the appellate division, while in the meantime, 13, 14 years passed, and every day of those 13, 14 years, the neighbors will have spat at each other. They see each other's face and they go the other way. They see each other in the morning and they swear at them. And the children do the same because their neighbors are bad, because the father has said so. And this goes on and on and on unnecessarily. And I probably one of the judgments that I delivered in Bangla, for the people at least to understand that this type of case should never have gone to the courts in the first place. So mediation is the answer. And once you get people to know the benefits of mediation, then it will take off. And I had dreams, as I said, of starting an academy for training mediators and arbitrators. But of course, as you know, I didn't get that far.
Thank you, sir. I think where you left off, I think maybe BIAC and SARCO's training programs could fill that gap. So we have our last question. So question for Saqib Mahboob sir. ADR is growing in Bangladesh, yet many businesses still hesitate to use it. Is this hesitation rooted in weak enforcement, lack of skilled institutions, or simply a trust gap? And how can we bridge it so businesses feel confident choosing ADR for trade disputes? Mr. Mahboob, if I could ask you maybe to just briefly answer this, since we are already beyond the time limit.
We are way beyond the time limit. I will keep it light. I would say that I have a very cynical view, unlike my Lord Mr. Justice Amy Manali. I have a very cynical view of my countrymen. I think if you see in Bangladesh, if you see the use of traffic lights in Bangladesh, if there are traffic lights, doesn't matter if it is red or green, no one stops. But if there is a police constable waiting at the other end, then they will stop at the red light because there is a consequence of violating the traffic light. So if in order to popularize ADR, the only way to do it, I believe, is for there to be a consequence. In Bangladesh currently, there is ADR, there is a lot of arbitration in a specific few sectors because there is a consequence. If you see that there is in the real estate and Development Act, there is a mandatory arbitration required. So if you actually don't go to arbitration and if you take your dispute to court, your case will be thrown out because the other side will come and say, or the court itself will say you have to go to arbitration, so your case is thrown out. So there is a consequence. You cannot avoid the ADR. Whereas for our mediation provisions, be it in the Orthorin Adalat, the Money Loan Court Act, be it in the CPC, if you don't do the mediation, if you don't go to ADR, there is no consequence. So parties don't follow it. So unfortunately, there has to be a negative consequence. No one will, I believe that no one will want to go to ADR because of the goodness of their hearts, because of they believe that this is a good way of resolving disputes. They will do it only when there is a negative consequence put on them. There is a fine, penalty, something put on them to force them to go to ADR, and that has worked with the real estate sector actually. In that now the biggest source of arbitration briefs, I believe, in Bangladesh is real estate. Huge number of landowner and developer disputes has now grown, and that all of that is going to arbitration. Another sector is construction. In government and construction, government has a policy of putting arbitration clauses in the construction contracts. So all those disputes are going to arbitration. And the only other one is cross-border contracts, and where, because it's a cross-border contract, parties favor arbitration. So there is arbitration. No other sector. Sorry, there is another one which is energy disputes, where in the law it says that you have to go to arbitration to the Bangladesh Energy Regulatory Commission. So apart from there being mandatory ADR, no one wants to do ADR so far. So my suggestion is have to put ADR in the law. If you don't do it, there is a consequence. If you don't go to ADR, then your case will be thrown out. If you have come to the court without first exhausting meaningfully the provisions of ADR. That is my offhanded light suggestion.
Thank you.
Can I just add again here, on the, I think, 21st of March 2021, the Supreme Court issued a circular. I mean, it's sad that we had to issue such a circular, but we had to issue a circular saying that the Code of Civil Procedure, Section 89A and 89C, the Orthorin Adalat Ain, Section 22, the Arbitration Act, Section 22(1), Bangladesh Labor Code 2006, and other laws, mediation is compulsory, and it is hereby directed, or I should say ordered, that the judges must enforce those laws. And I think in some other context, I also got the Supreme Court to issue a circular saying that these provisions of law are meant to be followed by the judges. And if they do not follow the mandatory provisions of law, it will be implemented through ACR, their record showing that it is a misconduct on their part, not implementing the law as it should be. So yes, I think Sakib Mahbub is absolutely correct. You have to have consequence. And I think here is a way of making sure that the judges realize that if they don't follow the law, in other words, mediation is compulsory. In other words, going to mediation is compulsory. Going through mediation, ending mediation is not compulsory, of course. It is voluntary. But you have to go to mediation first. You have to realize what the benefits or disbenefits are. And if after that you do not want to go through mediation or ADR of any other sort, that's up to you. But you must go. And who will enforce that? The judges will have to enforce that because the law says so. And if they don't enforce it, then misconduct on their part. I think that's the only way to get them to utilize it.
Thank you, sir, and thank you for those ideas as well. So, ladies and gentlemen, we've reached the end of our webinar. I extend my heartfelt gratitude to all the speakers, to our special guest for being such an integral part of this webinar. It has been inspiring to see the level of engagement by the guests as well as by the audience member as well. And I hope we can learn some insights which can play a very crucial role for Bangladesh's ADR landscape. For the closing remarks, I would now like to invite Mr. Mohammad Anisul Haq Imran, Senior Counsel of Bangladesh International Arbitration Center, to deliver the closing remarks.
Thank you so much. On behalf of BIAC, it is both a privilege and an honor to express my heartfelt gratitude to all those who have participated and contributed to the success of this remarkable webinar. I would like to begin by extending my deepest thanks to our chief guest, Mr. Justice Muhammad Iman Ali, sir, former senior most judge of the Appellate Division, Supreme Court of Bangladesh, whose distinguished career in the Appellate Division and High Court Division of the Supreme Court of Bangladesh has set an exemplary standard for the legal community. We are deeply grateful to you, sir, for your insightful special remarks, which have added immense value to the webinar. Your presence here today has been truly inspiring, and we are privileged to have you with us. A special thanks goes to Mr. Choing Dorji, the Director General of the SARC Arbitration Council, for his leadership and for organizing such an important event. Your dedication to advancing the cause of arbitration and ADR in the region is truly commendable, and we are grateful for your continuous support in making this event a success. Our sincere gratitude extends to our distinguished guest speakers, Mr. Justice A.F.M. Abdur Rahman, sir, former Justice of the High Court Division, currently Senior Advocate of the Appellate Division of the Supreme Court of Bangladesh, for your exceptional remarks on evolving legal and judicial attitudes towards ADR. Your insights have deepened our understanding of the evolving landscape of the ADR in Bangladesh. Mr. Muhammad Farooq Rahman, sir, Head of Chambers of Rahman's Chambers, for your enlightening presentation on institutionalizing ADR in Bangladesh. Your thoughts on this institutionalizing process were both informative and forward-thinking, and we appreciate your expertise. Mr. Saqib Mahabub, sir, partner Mahabub and Company, for your comprehensive discussion on cross-border ADR and regional opportunities. Your remarks has provided valuable perspectives on how regional cooperation can be strengthened through ADR, and we thank you for sharing your expertise. We would also like to express our gratitude to our moderator, Barrister Saqib Mangrio, Assistant Director of SARCO, for expertly guiding this session. Your ability to steer the discussion with clarity and precision has been invaluable in making this webinar run smoothly. Finally, I would like to thank all the participants and viewers of this webinar for their time and engagement. Your presence and active participation have made this event truly meaningful, and we hope that the discussion today will inspire further development in the field of ADR, both in Bangladesh and across the region. As we draw this session to a close, we are reminded of the importance of collaboration, dialogue, and continued efforts in advancing ADR as a key tool for resolving challenges and exploring opportunities in trade and commerce. Thank you all once again for your invaluable contributions. Let us continue to work together in making ADR a central part of Bangladesh's legal landscape. Thank you.
Thank you for the kind words, Mr. Imran, and thank you everyone for joining. We'll be concluding the webinar. Hope you all have a good day, and thank you until next time.
Thank you very much.
Assalamu alaikum.
Assalamu alaikum, sir.
Allah
Take
Hafiz.
care, everyone.
Everybody,
Be
assalamu
safe
alaikum.
and be healthy.
Assalamualaikum, sir. Assalamualaikum, sir.
Assalamu alaikum. Wa alaikum salam.